Welcome to part two of We're Separating. Now what? I'm Jennifer Barkin, family mediator, with my co host, Jennifer Donison, family mediator. Hi, Jennifer.
Hi, Jennifer. Okay, let's get right back into the different processes. And
So, mediation is very popular now, especially since courts started recommending that people at least attempt alternative dispute resolution, ADR, I'll call it, and ADR mediation falls under the ADR umbrella. So, what's mediation?
mediation is wonderful for many people because, as you said before so beautifully, is that you don't want anyone else making decisions for you and your family. And whenever you're in a mediation session, the mediator doesn't tell you what to do. The mediator isn't going to prompt you into different things. The mediator is just there to try and help both parties come to resolution and to incorporate the things that they've both agreed to in a parenting plan or into a financial plan. But
Exactly.
this is a very helpful process if you are both wanting to move forward with your lives and just have everything down on paper to document it and then to move forward and to have you both make decisions together.
So, a couple of nice things about mediation. Number one, people are in control of their destiny. Number two, it's a lot more economical than some of the other routes, like litigation. Um, People are making decisions for their own lives. And what the research does show is that people will tend to abide by decisions that they've had a part in creating rather than if somebody's told you what to do,
Yeah.
you may not follow what you're supposed to do because nobody likes to be told what to do. Um, it can happen very quickly and it can help build trust, which is a very nice thing when children are involved for the relationship to improve
Right.
between the parents, between the co-parents. So that's something nice about mediation. Mediation, however, people do not walk out of mediation with a binding agreement. They will have mediation summary notes or memorandum of understanding, which can be put into a separation agreement. But until the separation agreement is signed and witnessed, it's not legally binding. So that's something people should know about mediation.
Mhm. That's a very important point to make because many people that contact me ask, well, do I need a lawyer as well? And sometimes there's lawyers that are already involved and they suggest mediation for their clients. And sometimes the lawyers actually attend the mediation sessions. And if not, and if it is a if I say non-contentious, but if it isn't completely contentious and the two parties want to move forward together, I still suggest having independent legal advice done after the memorandum of understanding is completed by the mediator, because then they both have their own separate lawyers who will tell them exactly what it is that they're agreeing to. And even though they may know because it's been discussed in mediation, sometimes the lawyers will also make sure that they know what it is that they're giving up and that they could be going for, but they're deciding to say that they're foregoing. And that's important for people to know so that they're signing these agreements in a state of understanding everything that they're agreeing to. So even though you don't need to incorporate lawyers, it's a very beneficial thing to do so that you are in a clear mind moving forward, knowing that you are 100% with what it is that you're doing, but also so that the other party can't come back in a couple of years and say, I didn't understand completely. No one really explained it to me. I didn't have legal advice. I'd like to open it up again. And
Mm.
that becomes a problem. So if you both have legal advice and you're signing that you've had the independent legal advice and you do understand everything, it's less likely for this to be opened up and created a problem in the future.
One thing I find as a mediator, I like people to have independent legal advice. They don't always get it before we even go to mediation. Why? Because as a mediator, myself, you, we're not allowed to give legal advice. It's the unauthorized practice of law. So we're not going to tell people, well, if you went to court, here's what you'd probably get, or this is the amount of spousal support you would get. et cetera, et cetera. So even before mediation session, for people to know their legal rights and obligations can be very helpful in moving the mediation along successfully because typically, not always, people will not start digging their heels on something that's a loser that they know that a family law lawyer has said if you took this to court, it's not going to fly, because nobody really wants to spend 100,000, 150,000, whatever to lose. So while they may not like it, they're going to come to the mediation usually more willing to compromise
Hmm.
the other person. So I think that's important for people to know.
There,
And at any time during mediation, I mean, I'll find if people are starting to get stuck, I might say, let's just park this for a little bit and move on. We have things to do. Um, and get some legal advice around this issue. Because again, they're going to come back when we resume, maybe in a different mindset.
mhm. And just like collaborative law, when there's the stigma around when there's a little bit more contention in a situation that it maybe isn't appropriate for mediation, again, that's just the stigma because there are all kinds of people that go through mediation, whether it's a very high conflict situation, even, sometimes when there's unfortunately violence involved and different things. Nowadays, there's so many different protocols we can put in place to ensure the safety of the people going through the process. So
Mhm.
that separate rooms, even virtually separate rooms, different times coming and going. And, we always screen for domestic violence to understand what safety protocols to put in place. But it is appropriate for many, many, many different situations and is very cost effective to go through the process. And I mean, I obviously I'm a little bit biased because I am a mediator, but I think that it is the most effective process for a lot of different situations.
Mhm. And sometimes it's not appropriate, um, even though I will mediate domestic violence files, but it really, really depends. So, for example, both of us screen clients before we even enter mediation. And a question that I will ask is, other than with their hitting, spitting, kicking, shoving, pushing, I'll ask about sexual, against somebody's will. I'll ask name calling, coercive control sorts of things. And I want to know when these things happen because sometimes you might have an isolated incident that was so long ago and the people have been pretty safe and there isn't a lot of concern now. But if there's been, some recent things that have gone on, even with the video or the Zoom, and even with the scattered arrivals and departures, our first goal as mediators is to keep our clients safe. And sometimes it's not safe, and litigation is really the better route to go for those people.
Especially if the file is based on one of the clients um, being abusive in a sense where they wouldn't even want to settle, or they have this power over the other client that the other client would just agree to what they're saying in order to keep safe. So those are not appropriate for mediation, obviously. So, if that is the case, then obviously other protocols have to be put in place and other processes are more appropriate.
For
Litigation.
sure, for sure. So arbitration or mediation arbitration.
Mhm.
So mediation arbitration is mediation and everything's going the way mediation goes. The only difference is that mediator is also an arbitrator. So if people cannot come to agreement, that mediator then becomes an arbitrator and can make a legal binding decision. And as you beautifully said earlier, it's private, it's not going to be publicized, and so on. So
Mhm.
that's the med-arb process, as we call it. And then people can go directly to arbitration if they want with an arbitrator, which again, as you said, is a private judge. Um, you pay for it. It's not funded by the government, but it can happen quickly and resolution happens quickly and it helps families move on
Mhm.
instead of going through this years and years.
Right, because during litigation, as we know, uh, the court process takes forever. It's
It
so
takes
long,
forever.
And, things change so much, not just the situation, but the ages and stages of the children. And so many different things will change during that proceeding that sometimes it just is so not only financially draining, but emotionally draining that at the end of it, people are just depleted and it's so much more difficult to move forward. So it definitely isn't my favorite option.
I've heard a lot of lawyers say, do you want to send my kids to college or yours?
Right.
And that really says it.
100%. And then the other option that some people attempt to do is write a agreement together, just the two parties, and they try to figure out all. Well, it's true, they do.
Mhm.
No, it's important to mention because unfortunately, when they do that and things fall apart, they usually cause more harm than good because the agreement that they write together will be either missing things or they did not include very important things that need to be discussed just because they don't realize that that's something that can happen in the future. And then they don't have the independent legal advice where they are realizing what it is that they're entitled to or what they're actually signing off on. And when things fall apart, and they don't have anything put in place, then all of a sudden they start right back from the beginning and usually in a more contentious state.
Definitely. I would say that most of my parenting coordination clients um, have kitchen table agreements. And you've said it beautifully and hit on a lot of these things, that these agreements are often so loosey goosey. And no fault, I don't blame the parties because I'm always saying to people, I'm not a dentist. I don't know how to do a root canal. You're not supposed to know how to do these things. This is what we're here for. We're
Mhm,
here to guide you.
mhm,
This isn't not your wheelhouse. But things go missing. For example, you might think it's enough to say, and the children are going to be with the father on Christmas Day. And I'll be going, well, who's doing the driving and what time? And is it till the next day or is there an end to this? So many things like that we see. A biggie, one of the biggest is when there's young children, you can perhaps create a perfect agreement for what's working for the kids today. But what if they start not to work so well? What if things need to be changed? Now what? You may
mhm.
end up in litigation.
Right.
So people are not protected in the same way when they're doing these homemade kitchen table agreements.
Mhm. And many people, there's a cookie cutter agreement that fits every family. For example, there's really good templates out there that you could find. But the thing is that every family has specific situations that need a lot more attention to, whether a child has special needs or there's something in the family that needs to be addressed for a special holiday that's important to that specific family, or there's just always different things that specific families will need. And leaving a generalized cookie cutter agreement put into place can definitely do more harm than good. And like we mentioned before, just start a whole bunch more conflict and right from the beginning.
Absolutely. So I think we've touched on everything today, and I hope that our viewers and listeners found the information helpful. If any of you have any questions or you want to learn more, please reach out to Jennifer or myself, and we'll be happy to help you.